was the bloodlust was on. So that was a little trouble. Any of you have interesting weekend stories?
I've got a bunch of potential gigs lined up thanks to Elizabeth. So
potential gigs?
Mm-hmm.
For the cello?
Yep.
Meaning? Like musical gigs?
Mm-hmm. She plays cello.
Oh, you play the cello. Okay. Anyone else? Anything on your minds? Questions?
I do have a question about evidence.
Okay. About what?
I have a question regarding the situation in Dallas with the marijuana that they found in the apartment. It's irrelevant to what actually happened, so it won't be admitted into court, right?
Well, there are very creative defense lawyers in the world. And I could at least imagine ways in which they might argue that it was relevant and admissible. For example, if
That was a little different.
well, that was the first. In a moment. If somehow there was testimony that aromas led I can't remember the defendant's name, led her to go into the apartment. Now that's contrary to everything that has been in the statement so far. She said she went in there mistakenly. So why would anything that to do with the marijuana? So I can't. Certainly my sense would be it's inadmissible, and so that would be my guess. The very fact that information was released, or that there was even a warrant for it, is kind of troubling. So, listen. Okay. Anything else? All right, let's talk about proximate cause. And we're going to delve sort of deeply into some of the issues surrounding probable cause, some of the elements or some of the factors in proximateness as a factor in causation. And we'll do it by looking at 3 cases and see what we can conclude from them. And we begin with Rhodes. What was going on in Rhodes?
Rhodes, the defendant, was charged with deliberately setting fire in an apartment. The trainer, the firefighter, responded to the second fire alarm going off, and he had a hard time getting air to his face mask and collapsed. Later died in the hospital.
And he was wearing the usual firefighting gear, and there was intense heat, as you might expect, with a blaze like this, lots of smoke. So he collapses and was taken to the hospital, and
in the hospital, the doctor deemed that the technical cause of death is coronary thrombosis.
And what was the basis or the cause of the thrombosis?
Combination of variables such as cold weather, stress, smoke inhalation.
Okay, good. And with what is Rhodes charged?
He's charged with arson and second-degree murder.
Arson. Very good. The envelope. Get this out of the way quickly today.
Wow.
Arson is the word of the day. So he's charged with deliberately setting fire. Any problem with that? Or does there seem to be any issue with that? Just the arson charge looked at in isolation.
It says it was deliberately setting fire, so I don't see any issues.
No. The issues we're going to have are about the connection between the setting of the fire, that is the arson, and Trainer's death. Because he's not only charged with arson, what else is Rhodes charged with?
Second-degree murder.
Second-degree murder. And it's that causal relationship between the setting of the fire and the death that is our concern in this case. It's sort of the flip side, or an inversion of Faulkner, where you had another crime that led to the setting of the fire. Here's the setting of the fire that leads to another crime, right? So we turn that on its head. So on what basis does Rhodes challenge his conviction for second-degree murder in the death of Captain Traynor?
He feels
What does he say was wrong?
that there wasn't adequate causal connection.
Not exactly. Not exactly. Mr. Webb?
It's in the jury instructions.
The jury instructions, right? So he's not necessarily saying there was no causal connection, just that the jury wasn't properly instructed on how to decide whether there was a causal connection. So, Mr. Webb, what was the problem, according to Rhodes, with the jury instruction?
It said that originally the trial court said that it just had to be a contributing cause, which is inaccurate. He says it should be a cause which the natural continuous sequence produces the death, and without which the death would not have occurred.
Now, that's what we get from the appellate court. Rhodes, for his part, caused as much of this problem at the trial court as the prosecution did. What instruction did Rhodes ask for at trial?
Didn't he say that his action should he shown guilty if this was the sole cause?
Right. Rhodes at trial asked for a sole cause instruction. And if we remember Benji, that is at one extreme, pro-defendant extreme, of saying not only does it have to be foreseeable, not only does it have to be proximate, but there can't be any other causes. And here we have the weather, right? That he was not, that Rhodes was not responsible for, and the medical examiner said that was a contributing cause. So if we go to the sole cause instruction, then you could argue he should be acquitted, right? But that's no more an appropriate or accurate description of the law than what the trial court came up with. Because the trial court, perhaps, we don't know, the trial court might have said, look, we know this is wrong, so I'm going to go with the prosecution's position. And what was, Mr. Webb, give me a synopsis of the trial court's actual instruction.
It's a contributing cause. That means that if basically that in any way contributed to hasten or was part of the proximate cause. So if he did basically anything that led to anyway the fireman's death, then he's liable.
If he in any way contributed to hasten or was part of the proximate cause. The jury was also told Rhodes is criminally liable if Rhodes' act was a contributing cause of Traynor's death. What do you think of that? Or what does the Massachusetts Supreme Court think of that?
They think that there should have been there was no evidence in the trial court to show an efficient cause, which was a set of.
Don't talk to me about evidence. I don't care about the evidence. I care about the instruction.
But that instruction gave Rhodes potential liability for events that were not proximately caused by his plan.
And how do we? And what does the Massachusetts Supreme Court give you any guidance on what more it has to be than merely a contributing cause? Mr. Webb's also, you already used the term.
He said it had to be an efficient cause.
Okay, and what is it? I mean, I don't know what that means. I don't know what that means. An efficient cause. I'm like, okay.
The cause that necessarily sets in operation the factors that cause.
So like the procreation of John Wilkes Booth's grandparents necessarily set in motion the chain. Is that good enough? No. No, the Massachusetts Supreme Court uses a term, a particular phrase to say what it thinks.
Was it the natural and continuous sequence?
What was it again?
Natural and continuous sequence.
Natural and continuous sequence. That's what proximate means, if it's in a natural and continuous sequence. And when you read that, how many of you thought, oh, now I get what proximate is? That really helps me to sort of, and if I were on a jury, I would know where that line is. Because remember, we've had this line among all the links in the chain from here is Booth's grandparents, and here is John Wilkes Booth firing the shot. Right? Somewhere along the line, in between, where we said this is not proximate, this surely is proximate, somewhere there's a line between but for, but not proximate, and proximate. The Massachusetts Supreme Court says natural and continuous sequence defines this line. Is that a helpful place, a helpful phraseology in drawing a line? My answer is,
No.
you've done us no good, Massachusetts Supreme Court. Right? You have to reverse, because this instruction doesn't capture it. But they haven't really been very helpful in giving guidance for the remand or to future juries or to trial judges who have to give instructions about language that will actually help guide juries. So Rhodes is kind of a helpful case in one way, in that it says, okay, we can rule out simply a contributing cause. We know that's not enough, but it doesn't really tell us much that's helpful beyond that, okay? So we see what's bad about the trial court's instruction, but we don't see much else, okay? Any other questions about Rhodes? And then I have a little surprise for you. Did you say, uh-oh? This hurts my heart, right here. No, this is a good surprise. And that is, I want you to look at the snapshot review on page 307. Okay? There are 4 questions there, and this is your next voluntary assignment. Right? If you complete this and email it to me by the end of the week, you will get extra participation credit. Okay? Your answers should be at least on each of A through D, 1 paragraph, and no more than 1 paragraph on each, explaining why you came to the answer you did. Okay? By the end of the week, so by Friday. I have it by Friday, and then I'll get your comments back. Everyone understand the assignment? Any questions?
Do you want a hard copy?
I would prefer email, but a hard copy is fine. Just get it to me. Okay? Yeah?
You say 1 paragraph per?
1 paragraph for each. No more, no less.
Did you say what time Friday?
I did not.
So,
Whenever. Friday. Eastern Standard Time. Anytime Friday. So if you get it to me at 2 a.m. Saturday and say, well, it's still Friday in California, that's not going to work. But our time by any time Friday. Okay? Any other questions? Okay, this is actually an extra one. So there's still an assignment to come and then another question to come. So there's going to be a total of 4. I decided I'd add an extra one in. Okay? Because you're not busy enough. Okay. Well, that leads us to one of I think, the most interesting cases of the semester. Every time I teach this case, something different happens. So we'll see what happens with you guys. Tell me about Root and how this trouble all began. Mr. Razor, is it?
Yeah.
Mr. Razor.
Root was street racing against a competitor, and they were racing on a rule.
And why isn't the competitor charged here? The competitor is very, very dead, right? Now I should tell you that on an exam one time, I gave a question that involved some people dying, and I would say 3 to 5 of the students in the class on that exam what they had to do was they were an assistant Commonwealth's attorney, and they had to write a memo to the Commonwealth's attorney recommending what charges should be filed. Okay? And why they thought they could convict the people they were charging on those charges. And I'd say like 3 to 5 of the students decided to charge one or more of the dead people. Okay? And I had to give them some credit for being aggressive. They were aggressive prosecutors. They were going to charge no matter what. But I had to say, it is customarily not the practice of most prosecutors' office to charge people who are dead. So just a word to the wise. If you notice on the exam that someone is dead, don't either think you're going to defend them and don't argue that they should be charged. So here, the deceased is not charged for obvious and good, sufficient reasons. But Root is. So tell me a little bit about the circumstances that led to these charges.
They were racing on a rural highway. It was 3 lanes, but in the accident, it condensed into a 2-lane on a bridge.
And what was the speed limit?
50 miles per hour.
And how fast were they going?
70 to 90.
70 to 90. So they were moving. So what happened when they got to this bridge?
Root was in the lead of his competitor, so the competitor tried to pass, and when he passed, he hit an oncoming truck.
And I love the way the court puts this. He swerved his car to the left, crossed the dividing line, drove his automobile on the wrong side of the highway, head-on into an oncoming truck with resultant fatal effect to himself. Gotta like that. So the court says, well, look, there's lots of things you could charge Root with. For example,
Speeding, reckless driving, perhaps other violations of the speed.
right? Lots of things you could come up with as a creative prosecutor, just sitting there in the statutory code to charge Root with. But instead, or in addition perhaps to those, what is he convicted of?
Involuntary manslaughter.
Involuntary manslaughter. So what are the elements of involuntary manslaughter?
Unlawful or reckless conduct.
Unlawful or reckless conduct. Is there any issue with that one? With that element being present on Root's part?
No.
No. He engaged, we just said, in conduct that could be a violation of various elements of the vehicle code, on speeding, on reckless driving, etc. So it's the unlawful conduct is there, and since reckless driving was one of them, we have reckless conduct if we want that one. So that's met, no question about it. There was unlawful or reckless conduct here. What's the other element, though?
That the reckless conduct charged the defendant with the direct cause of the death and issue.
And that is a different story in the court's view, okay? So why does the court conclude that this element is missing?
Because the approximate cause is not enough.
Good. The court says we reject the use of proximate cause. That's the first answer. Why? Why does the court say proximate cause alone is not enough? What's the court's concern?
That it's used in tort liability, but it's not enough for criminal liability.
It's not just that it's used in tort, but what's happened in tort law according to the court? I beg your pardon?
They've extended it considerably in recent years.
Excellent, right? At least the tort concept has expanded in recent years, the court says. Right? The tort concept has expanded in recent years too much, to allow too much conduct to be the source of liability for criminal law. And there may be good and sufficient reason for that in tort, because we want to have an expansive view of conduct A that caused result B in order to provide compensation for victims, right? But when criminal culpability is attached and all of the consequences for defendants, the court is not comfortable with that. Okay, so the court says we reject it as it has expanded. So we're going to cut it back. We're going to require more before we're going to say that causation exists for criminal purposes. Well, my question then is, what is it that the court says is missing here from the causation that should be required for criminal law? What else, or what about this is too broad, or to put it in the converse, why does the court say there's something missing from what we should say Root had to do or what Root had to cause?
That he was aware of the dangerous condition created by the rapid.
And what's another word for that, his awareness? Well, it's the same word we talked about last week.
Knowingly?
Not knowingly. Foreseeability. One of the court's answers is, it wasn't foreseeable. Oops. And we'll talk about the other answer in a minute, was foreseeability. The court said on 311 and 312, to have this tort concept would be to expand possible criminal liability to persons chargeable with unlawful or reckless conduct in circumstances not generally considered to present the likelihood of resultant death. Right? And then the court presents a bunch of tort cases where it would seem outrageous, right? Where the resulting death seems so unforeseeable from the conduct involved in those cases. Okay? So if the problem with extending tort-type proximate causation is that it renders the harm unforeseeable, I have one other question for you. Does that make any sense to apply in this case? Who wants to be Root's prosecutor? No one. Okay, Mr. Razor, let's say you buy, or you're at least willing for the sake of the argument, to buy the court's problems with cases in which the resulting harm, in this case death, was not foreseeable. What can you still say about this case? That it was foreseeable, and give me that argument, tease that out.
Because they knew that recklessly driving could lead to death, and therefore having a car going 90 on a two-lane bridge.
Why does the criminal law make drag racing illegal?
Because it harms the other drivers, danger.
Or, put it more in terms of this foreseeability argument.
Before?
I'm sorry? Happened before, or more generally?
It puts the drivers at risk.
I beg your pardon?
It puts the drivers in danger.
Puts everyone in danger, and what danger are we worried about that's the reason we make this criminal, Mr. Smith?
Death.
Death. We are, in fact, worried. The reason we criminalize drag racing is because we're worrying somebody, might be somebody in a car, an innocent bystander, or somebody who's a participant, somebody's going to die, right? So it's exactly foreseeable that this might happen. This particular argument by the court is just mind-numbingly dumb, right? And as applied to this case, it's a real, genuine concern about how many causes we want to allow to be to result in criminal culpability, right? If something just is not foreseeable, right? No one could have anticipated this, then charging somebody, ultimately you get the Faulkner problem. You get the Faulkner problem that you are transferring intent. The fact that somebody did crime A becomes the basis for culpability B, even though they couldn't foresee it. So we want to require foreseeability, but here?
So my issue isn't with death not being foreseeable.
Okay.
For me, it was the victim swerving into oncoming traffic.
That's the second point.
Like, no matter how bad I want to win, I'm not going to do that because that's just,
Have you ever drag raced?
I've been the passenger.
That's the second most dangerous thing you've ever done in your life, I'm willing to bet. Second only to enrolling in law school. That's arguable. Okay? I'm going to bet that a lot of people who have drag raced have, in fact, done incredibly dangerous things in the adrenaline rush of trying to win. Right? Swerve into oncoming traffic. Well, maybe there won't be a truck coming in there, and and that's how I'll win. Right? I'm gonna say, and I know this is a generalization, I don't want to stereotype drag racers. Some of you may have done it in your lives, and I mean no offense. The kind of people who drag race are also the kind of people who are going to take ridiculous chances when they are drag racing. That's my own view. But again, that may be a stereotype. But I do want to hone in on what you said. So when you say he swerved into oncoming traffic, what are you identifying that as?
That's irrational.
Well, it's irrational legally, though. An intervening cause. And that's the second thing the court says. If we, and you don't have to, but I do, if you reject the application of this one to getting Root off the hook, because it was in fact foreseeable, we still have this one, that the behavior of the dead driver is an intervening cause that cuts off the chain of causation. And one thing you have to build into your analysis, one factor you have to take into account, is this idea of an intervening cause. That something that might otherwise be on this side of the line, like the decision to drag race, can be cut off by an intervening cause. And we saw this with Hubbard. Hubbard's heart condition could be seen as an intervening cause, or the jailers, the sheriffs, whatever he was, his heart condition is an intervening cause, even if we had said that it was foreseeable for resisting arrest to cause a heart attack, right? So if you have an intervening cause, and the thing that the defendant did is otherwise here. It's on this side of the line. It's not merely but for, but there's something intervening that causes the outcome. That is a basis for denying causation.
So I'm trying to think of like how to word this in notes, but could you say that intervening causes nullifies foreseeability, or
You could.
I'd say that?
You could. So the intervening cause is a circumstance not attributable to the defendant, which is the reason why it happened. Is the reason why it happened. So if we say that something is an intervening cause, we're saying of the result. Then we're saying that the defendant can't be liable, can't be culpable, can't be convicted of that result. So what was the decedent's swerving the intervening cause of, Ms. Mwanga?
I'm sorry,
What
what?
was the decedent's, the dead driver's, swerving into the truck? What was that the cause of?
The drag race?
It wasn't the cause of the drag race. The drag race started before. When he swerved, what are we saying that was the cause of, which makes it an intervening cause, so we can't hold Root culpable? The death or the accident. I like that better for my purposes. It's an intervening cause of the crash. Of the crash. Okay. Now I have another question for you. What if the dead person was the truck driver? Once we say that the other driver swerving is the intervening cause of the crash, and that lets off root, do we also have to let them off and say it's an intervening cause, since it's an intervening cause of the crash, whoever dies?
I would say that it's unforeseeable from the truck driver's perspective that someone's going to swerve onto
Did we even ask whether it was foreseeable from the dead drag racer's point of view? We said it was an intervening cause because it was foreseeable?
I would say that reckless driving is foreseeable, so it's foreseeable from his perspective versus the truck driver who's just driving normally.
But these are two separate questions. One is the death foreseeable, or is the crash foreseeable to root? And I suggested to you, I think it clearly was, just from drag racing. This question is not, was it foreseeable to the dead driver, but was the dead driver's actions, were they an intervening cause that, even though it was foreseeable, let's root off? So don't sort of combine foreseeability and intervening cause.
I think if the truck driver is killed, there's a stronger case to file as an accomplice. You would say that Root is an accomplice to the involuntary manslaughter of the truck driver by his friend who was racing.
Then why isn't he an accomplice in the racer's own death?
Because he can't get, because I think it's different because if there's not an intervening, it's hard to say, sorry.
Go ahead. I love where you're going, because that leads me right where I want to go. Keep going. No pressure.